I'm starting with the process. So welcome all of you. Welcome to the 26th edition of Junior Faculty Forum Workshop. So today we have Vijay Tyagi's paper on anti-defection law. That's what we are going to workshop today. A quick point to all of you is that we'll actually start with the discussion point from our discussant, and then we'll actually straight away go to the author's response on that. So before that, just quickly to mention regarding the paper, it's Vijay, who's a PhD scholar at University of Delhi. He has provided a draft paper titled Anti-defection Law and Issuance of Whip, a comparative study of its impact on parliamentary democracy in India, Bangladesh, and Pakistan. It's a draft paper which we all received. It's very interesting to look at the area of how executive accountability as well as separation power issues have been raised. And it is all the more important for our Junior Faculty Forum, especially since we are looking at South Asia as a major area. And this is a topic which has been studied on a comparative perspective from India, Pakistan, and Bangladesh context, constitutional context. That makes the paper all the more interesting for our Junior Faculty Forum to workshop on it. Also, quickly welcome Professor Siddharth Chauhan. Siddharth joins as a discussant. Thanks, Professor Siddharth, for taking out time and being here to talk and provide points on this paper. Professor Siddharth is a faculty with the National Law School at Hyderabad. Hyderabad is a faculty with National Hyderabad. Also, I would like to just take 1 minute regarding a quick welcome, official welcome to our new team members who have joined the JFF Executive Board. So we have a 4-member new addition to the JFF board. So they have excellent academic stellar record of all the members, as well as they have been contributing towards the running of our coordination and running of our workshops. And even today's workshop also has been largely coordinated by our new members. So I'll just quickly introduce all of them. We have Varsha Aitala. Varsha is a PhD scholar at National Law School, Bangalore. We have Rohini Sen, who is PhD candidate at University of Warwick. We have Mini Saxena, who is PhD candidate at SOAX, University of London. And we also have Aditya Vikram Sharma, who is an assistant professor at WIPS Delhi. So welcome, formally welcoming all the other new members, and they're already contributing immensely to the JFF forum, as well as we are already seeing the more enthusiastic sponsors as well as contribution from the new members. So just a quick note of official welcome to all of you also. So with that, I'll hand over the floor to Professor Siddharth. Siddharth, we can actually start with the discussion on the points of the paper. So over to you.
Thanks, Deva, and thanks, Swati and the others for inviting me. To be completely honest, Professor Tarun was asking me to join this forum a while back, but between handling lots of issues with students on a residential campus and family, I've had a tough time logging into the sessions. So this is in fact only the second time that I'm joining a JFF meeting. So due apologies to Tarun for my delayed entry, but I do hope to compensate for it by making a presentation of my own later in the year. So the paper which Vijay has written, I'm guessing, is part of a larger project. I mean, I wasn't able to deduce what that larger project is from the paper itself, but it was useful to look at it because as an instructor for constitutional law, at least in the school where I am currently, we've organized the study of constitutional law into fundamental rights in the first part and federalism and separation of powers in the second part. And actually, the separation of powers part suffers in terms of delivery and classroom engagement because it's also the same term where we end up doing administrative law. But in spite of that, anti-defection provisions are in fact quite an interesting topic. And my intervention actually comes more from how I've tried to explain this to my students rather than any serious scholarly engagement with that question. So I should begin with that disclaimer. So usually when we try to introduce the context of the 10 schedules insertion into the Indian Constitution, we pretty much make the point that Vijay is making in his paper, where he points out the examples of defections, especially the ones which were documented from the late 60s onwards, to a larger pattern where we find that in many state assemblies, defections were largely happening for selfish reasons. And that, of course, adds to this narrative that the central government must use its parliamentary majority, which the Rajiv Gandhi government had, to do something about this problem of crossovers and defections, which in a way is also part of a larger story of the Congress system breaking up into smaller regional parties. In some cases, defections were strategically used by opponents of Mrs. Gandhi. In other cases, it was Mrs. Gandhi herself engineering defections to ensure that Congress comes back to power. So I think for a person who may not be rooted in the study of the Indian Constitution, and if the point is to ensure that this paper is read by a broader audience, it might help to have a little more of that context coming in when the author is discussing the context of the 10th schedule. But when it comes to the actual argument of the paper, which is to compare the anti-defection provisions in the 10th schedule, the paragraphs which are enumerated, with the changes in the Pakistani constitution and also in the Bangladesh constitution, I felt there's another opportunity to perhaps emphasize why the anti-defection provisions in Bangladesh actually are far more closely connected to the origins of their formal nation state than perhaps in the other two countries. So I know Vijay does touch on this point, and it is clearly made. But if the paper is meant for a broader consumption, then perhaps it can be pointed out that there were attempts to take legislators away from the Awami League when Sheikh Mujibur Rahman had won the election. And that contentious period actually is connected to the set of events which leads to the massacres in Bangladesh, and then, of course, the war that takes place. So I think for a paper which could be easily read by students from other jurisdictions and people like us from other jurisdictions, it may help to maybe reflect a little bit more on the political context leading up to these changes. But in evaluating the argument, I think the argument is set out very clearly that in the context of Bangladesh, or to a large extent in the context of India, the enforcement of the whip, which is seen as the primary disciplinary mechanism, has actually led to a pattern of the executive dominating the legislature. By and large, the ruling party or the ruling coalition has been able to draw advantages from whips, where even in questions where individual MPs or individual legislators might have perhaps had a different view, the incumbents are able to have their say. So the argument, I think, is now being made quite often that while the purpose of the 10th schedule was to enhance regime stability, it has come at the cost of individual initiative and perhaps the negative impact on inner party democracy that we have seen. So I thought that theme is fairly clearly engaged with. But the author also, I think, I must appreciate the paper for making a very specific conclusion rather than making a broad-based observation, as one can see in the literature, where his point is that in one jurisdiction, the pattern seems to be more of the executive gaining control over what happens in parliament, whereas there's also a larger thematic question about what this means for the formal separation of functions. So my only suggestion there is that since the author does look at the amendments in Pakistan as perhaps an alternative, where he says that maybe the issuance of the whip can be limited to situations which threaten regime stability. For instance, there is an amendment which says that only in the case of electing the prime minister or the chief minister, or for that matter, debates on money bills or no confidence motions might be the unique circumstances where a whip might be justified. And if you read the paper at first glance, it seems as if the author is endorsing that as a potential solution. So there I would perhaps put on a slightly critical hat and say that maybe that point requires more substantiation. Because if you feel that regime stability should be the only criteria for enforcing the whip, you might face criticism or arguments which point out other scenarios which may not directly involve regime stability, but might still have an impact on policy at large. So the Pakistani amendment, of course, includes money bills, which I guess would account for the annual budgets, which in a way, in normal years, should reflect the spending by the state exchequers. but one can visualize certain scenarios where decisions about finance may or may not be characterized as core regime stability questions, especially important changes to taxation law, or for that matter, extraordinary thunderbolt events like demonetization. So even though that there's a separate debate about whether or not demonetization should have had a legislative basis more clearly, but my only concern is that maybe that conclusion where you seem to be endorsing the Pakistani conditions could have been framed with a bit more context and a bit more explanation about how that's different from the situation that you have outlined in India and Bangladesh. So I'll try and just limit my comments to a few more minutes. The other concern which I slightly have with the construction of the paper is that when you set out your method, of course, it is comparative work. And the obvious choice of jurisdictions is shaped by colonial history and territorial continuity. But if we do look at the basic literature in comparative law, I think we also have to try and see what sort of theoretical framework might justify such a comparison. Because if somebody had to nitpick on the choice of jurisdiction, one could say that there are differences in the way in which the political culture has evolved and shaped over time. And certainly the creation of Bangladesh follows a very different trajectory as opposed to the original creation of India and Pakistan a couple of decades prior to it. So you may find discussants or commentators elsewhere who may ask you much more foundational questions about why are we comparing these three jurisdictions. As a person who is teaching Indian constitutional law to Indian students and the occasional Bangladeshi and Nepali students, sadly we don't have Pakistani students, for me it's relatively easy to say that this is the context because we are following on from previous courses in colonial legal history. But I think if this work has to be presented to audiences outside, you may require some explanation of why the choice of jurisdictions actually allows you to investigate your question with more depth. So I know that your paper simply refers to the fact that the three jurisdictions have chosen Westminster models, eventually in different forms. But apart from the choice of format, the choice of parliamentary democracy, what other intrinsic feature is connecting these three jurisdictions? So I think apart from colonial continuity or apart from territorial contiguousness, you may need some other arguments to back up your choice of jurisdiction. I'm not saying it should be limited to something like a functionalist account of parliamentary democracy. That may not be the best method to say it, but perhaps a comparison that is grounded in the fact that the evolution of the party system is more or less in many parts of these three countries also tracking subnational and regional identities. So in that sense, the role of political parties in the long run is not just fulfilling the role of forming stable regimes, but also giving voice to subnational and regional groups, which otherwise will find it hard to capture power in the center. Because much of the story of the 10th schedule is also about how it is strategically used in the context of undermining or sometimes enhancing the interests of smaller regional and state parties. So is there a point of comparison between the three jurisdictions, which goes beyond the shared history of colonial rule or territorial continuity and looks at the possibilities of federal relations? I think that was the point which was coming to my mind when I read your paper. I'm not quite sure. I don't think I framed my comment clearly enough, but that could be another angle which you could bring in to explain your choice of jurisdictions. On the materials, I think I've already touched on it in terms of maybe a little more context on the formal changes which happen both in India and Bangladesh. With Pakistan, I felt that you are in a way making a point of departure from India, but we acknowledge the fact that Pakistan has also had a fairly chaotic multi-party democracy. And the changes made in 1997 themselves may in fact have not really had the impact that we are looking for. So especially since you seem to be endorsing the Pakistani example, if I'm wrong, please correct me, but at least when I read it the first time around, I read it a second time around, it appeared as if you were suggesting that the most strategic measure would be to limit the situations where whips can be issued. So in a way, you seem to be endorsing the Pakistani experiment. But there again, somebody from another field, let's say somebody from who works on political science in a more empirical way, might challenge you and ask, but have you looked at the actual effects of whips on, let's say, regime changes or legislative paralysis later on in Pakistan? So maybe that is part of your larger doctoral project. Maybe I'm jumping the gun, but that could also be a potential question that you may have to deal with. A last point which I had written down is about looking at the sort of theoretical approaches that some of us could be using to study parliamentary democracy. So of course, if we link it to the formal study of constitutional law, you have that old mainstream narrative that the constitution can be looked at as a historical exercise of creating a post-independent state, which is in a way aiming for national integration, building electoral democracy, pursuing social reform, the standard sort of Granville-Austin account of how the constitution marks a break from the past. But if we jump to the opposing standpoint, which perhaps begins with Professor Bakshi's famous review of Granville-Austin's work, he seems to be more interested in constitutional silences, right? The idea that certain interest groups were either systematically underrepresented or were perhaps unable to represent themselves in the original framing of the constitution. So even though that theme has not been directly correlated to the study of parliamentary democracy in the context of anti-defections, one can certainly make connections with the growth of the party system and the splintering of parties over time with that original insight about constitutional silences, that there are certain issues which were perhaps deliberately left unaddressed, and there are certain issues which were not addressed largely because of the lack of representation or the lack of formal channels for certain groups to put forward their views at the stage of the drafting. So could we say that the experience with anti-defection provisions to some extent is also tracking the possibilities of those constitutional silences? For instance, are there policy questions or legal questions or even the framing of the 10th schedule itself, let's say in the Indian context, which is addressing an issue which perhaps could have been handled better if there had been stronger representation in the Constituent Assembly of smaller or regional parties? So I know I'm stepping beyond the logic of the discipline, but I'm sure many others in the group here are familiar with the older work of scholars like Aditya Nigam or Nivedita Menon, who've in fact been arguing this for a long time, right? That let's not read constitutional law just literally as a set of sources which we can interpret to solve our problems today, but let's also try and apply some form of counterfactual thinking to argue what could have been the alternative possibilities if certain interest groups had been represented. So I know it sounds challenging, it's a bit difficult to do, especially when you pick up a doctrinal topic and your conclusion is so clear and neat. But depending on what you will tell us about your doctoral project, that might be one angle which you might want to use. It may not be specific to just anti-defection provisions, because the burden of justification there would be that the strategic use of anti-defection provisions in some cases might have enhanced the power of smaller or regional parties, whereas in other cases, as you have tried to say, it reinforces the larger idea of dominance by the incumbent. So I'm just wondering whether that's a line of argumentation, right, which may interest you. And just to quickly conclude, I'm sorry, I've taken, I think, one more minute than what I planned for. The sort of contribution, as I could see, is that perhaps we need a more robust discussion, not just of the procedures of parliamentary democracy, right, but the very cultural presumptions of parliamentary democracy. And here, I'm sorry, I'm stepping outside the logic of the paper. But generally, when we introduce constitutional law to our students, some of the basic questions that are coming up in the classroom, and this is not really a response to Vijay's paper, but an opportunity to maybe get some thoughts of the other colleagues here. When we introduce, in fact, I just began the rights course with our undergraduate students 3 weeks ago. And some of the basic questions start with what the literature has not perhaps fully addressed. That why exactly should we assume that parliamentary democracy was the best form of government for our respective cultures? That if we are still struggling to form a common core of a civil society, let's say at the level of language representation or at the level of educational institutions, students today in the 2020s are asking us that why are we still going back to this presumption that there was this common polis or a common forum, which was visualizing parliamentary democracy as an ideal form of government for South Asia. And to be honest, it's very hard to meet those questions because the skeptics, or perhaps the people who question the premise of parliamentary democracy, I mean, they are perhaps getting more attention on YouTube these days. I mean, that's the least I can say. So it's very hard to convey this idea to 20-year-olds that, look, parliamentary democracy may or may not have been formally rooted in South Asian culture in terms of historical evidence, but there is definitely a combination of colonial influences and learning from other jurisdictions, as well as the ideals of the anti-colonial struggle, which put us in that path. So more than teaching constitutional law, it becomes an exercise in introducing concepts in colonial history and trying to point out why certain departures were necessary. So I know I'm stepping outside the logic of your paper, but for I think anyone who's working on parliamentary democracy, whether it is anti-defection or the impact of coalition governments on decision-making, or I think the new issue is what are governors doing to the state legislatures? I mean, they simply decide to withhold assent to bills which are seen as taking away the powers of the center. So irrespective of the area that you're investigating, whether it has an impact on federalism primarily, or whether on the working of the parliament, I think these foundational questions perhaps also need some bit of reworking, because the existing literature somehow is not so easy to convey, to people who are getting introduced to this discipline. And the challenge from what we might call the populist voices is in fact very strong. Not a single class goes by unless I hear an objection which comes from the line of argumentation which says that all of this is Western imposition. Why are we studying this in 2023? And those questions are something which I didn't hear amongst my own peers 20 years ago, but I'm hearing those questions very often, as I said, almost on a daily basis. Right. So I think I'll close there.
Thank you. Thank you, Siddharth. Tarun, yes, shall I hand over to you?
If I don't know what the format is, you might want to invite Vijay to respond first.
No, I think
you can actually
take up the responses and then go to Vijay. That's perfectly fine. Please.
Well, sure. Thank you very much. So actually, it makes sense for me to go after Siddharth because Siddharth is really tough and and very intelligent. And I'm going to, as I was listening to him, I was thinking, what are the things that you could do in the paper to defend or to hedge your bets against or to respond to some of Siddharth's comments. In some ways, I'm talking to Siddharth as well, not just to you, Vijay. And this is really a treat. I think the paper was a treat as well. So a lot of what I will talk about is style as well. And maybe one helpful way to think about it might be to see, and Siddharth, please correct me if I'm wrong, see Siddharth's comments as the comments of a teacher and my comments as the comments of an editor. If I was a journal editor, what would I be advising you to do? And so the spin is slightly different, right? So I'm going to help us get some comments on the more prosaic job of how to get this published in a meaningful way. Whereas I think what Siddharth is pushing you towards is how to be a good scholar and how to think about the topic. And the two are not, in the long term, they are the same, they meet, but in the short term, they don't and probably should not meet because you don't want one paper to carry too much of burden. And so I'm being unfair to that because it's very clear that, it's going beyond the purview of the paper, right? So with that preamble, so let me start with structure because I think I'm very much, okay. So I think as an editor, the first thing I will worry about is that this reads like a student project. I don't mean that as an insult. It is something we see very commonly in early career scholars. And sorry for the presumption. I think you're an early career scholar. I don't know you well enough, but if you're not, just, slap me on the wrist and tell me to shut up. So I would package it differently because your voice does not come out as strongly and clearly and authoritatively as an author's voice should. So here is one way of how I might go about doing this, right? First, please lose the literature review section. You don't need to do, and you should not do a section on literature review in a journal article. I'm assuming this is going to a journal article. It's sort of that kind of space, right? You do need to engage with the debate on that topic and you must engage with others who have done it, right? But weave that intellectual learning from your predecessors throughout the article rather than parking it in one discrete section called literature review and then you're done with discussing those views, right? Because also there you're just telling but not showing, right? You're saying X has said this, Y has said this, Z has said this, right? But we don't know how those arguments work with your arguments, right? And which ones are relevant, which ones are less relevant, right? So you need to do that reading to write this article, but not everything you have read needs to be reflected on the article. So that's the That's the first advice I will give with an editorial hat on. The second is that a much clearer, arresting, direct framing would be. Labeling is a really useful and important skill in writing scholarly work, because you're writing for people who are usually really busy, really overburdened. You have to tell them why they should read your piece and not, the hundreds of others that they could be spending their time on, right? So accessibility is important. And your paper has a very clear thesis, but it does not emerge until much later, right? So just use labels. And I think the Pakistani model versus the Bangladeshi model, or the Indian model, or the Indo-Bangladeshi model, whatever you might call it, is a good way to frame it. And then I would start with that. To say, there are two approaches to thinking about anti-defection regulation in the Indian subcontinent. One is the Pakistani model, one is the Indo-Bangladeshi, or the other way around, right? And say that in the first paragraph to the reader, so the reader knows what it is this article is about and whether they should spend their time reading it or not, right? So that is a framing issue, and the whole paper should follow that frame, right? Having set up the frame, and this is sort of picking up on things that Siddharth was pointing to, right? What are the stakes? So, and this is all there in the paper. I'm just repackaging it, right? What are the values in tension in each model? So what is the values in tension in this debate? I can see two main issues. One is the priority of the party versus the priority of the legislator in the system, right? And the tension is created because in majoritarian electoral systems, whether first past the post, which I think all of these countries use, or under ranked choice voting, the electoral system prioritizes the legislator. So none of these jurisdictions have chosen the proportional representation method, which prioritizes the party, but anti-defection law appears to prioritize the party over the legislator. Right? So that is one central value contestation in your paper. The second one, the one that you frame it around, I share Siddharth's worries about, which is the executive and legislative framing, because executive and legislature distinction, right? First, the anti-defection regulation is supposed to strengthen not just the ruling party vis-a-vis its legislators, but also opposition parties vis-a-vis their legislators, right? So it's not self-evident to me. Why does this help the ruling party more than the opposition party? If that is your argument, that this skews the partisan balance, or works in favor of the ruling party, you need to say more, and that more will be context, right? So one objection to that view might be, like we all know about the Operation Black Lotus and the Amit Shah model of forming governments, right? So that seems to me to be a problem to which anti-defection law could be a response, and a good response, right? If it's effective. Problem is that it's not effective enough, but if it's effective, right? So, but that is a problem to strengthen the opposition parties vis-a-vis the ruling party, and not the other way around. So the assumption that you make, maybe there is no executive and legislature story to tell here. I think you should be open to that possibility that this is not about separation of powers, right? That which branch of government anti-defection law ends up favoring depends on the context. Sometimes it's the legislature that emerges stronger. Sometimes I don't know. I'm just speculating, right? The more obvious tension to me is between party and legislator, who is. And by the way, you must look at Aradhya Sethia's work around this issue. I don't agree with all of it, but I think it's some of the most sophisticated work on parties in India. So you really will benefit from it, right? So you set up the models, you set up the tension, the value-based tension, the normative tension that's entailed in the doctrinal distinction, right? And then you do proportionality, right? Which is, I read your argument as suggesting that in the Indo-Bangladeshi model is overkill, right? That you're taking a sledgehammer to crack a nut, right? That you don't need the comprehensive application of anti-defection law. to solve the problem that is at hand, whereas the Pakistani model makes a more nuanced proportional judgment, right? But anyway, maybe I'm reading your article wrongly, but that's one way to write it or to structure it, which is, what is the difference in doctrine, maybe some context, what is the normative stakes here, and then how do we resolve the normative dilemma? Because, if there are two values in tension, usually you have to figure out a way of optimizing rather than maximizing both of them because they're in tension, right? So that's broadly sort of comments on structure. And a few other minor comments, and then I'll shut up because I know I might be going on for too long. But, so this is on Siddharth's comments. I think you should read all the deeper inquiries that Siddharth has made as helpful advice for a broader research agenda, maybe for the next decade. Right? Answering all the questions he has asked you could take a lifetime, if not more. And I don't mean that as dissing them. I think you're onto something really important, and I think you should take him very seriously. But in this paper, I would respond to some of the deeper questions by using caveats to tell the reader that there are these other issues, but they're beyond the scope of one paper, right? So first is I would not be apologetic about the fact that it's a doctrinal paper. I think we need good, solid doctrinal work and in any legal system, and we have to stop being apologetic about it. Socio-legal work is great, and that has its own place. They're complementary, but not every doctrinal piece needs to be socio-legal. So I would not be, of course, it can be supplemented by socio-legal work. And that might reveal other truths, but so own up, don't be apologetic about it, but also say this does not provide all answers, right? I think some context will matter, historical context of both. By the way, on the jurisdiction choice, I think you should make a virtue of necessity and say that, you just spell it out that you are going against the grain of a lot of the doctrinal work in the global south jurisdictions, which just automatically, unthinkingly, unreflectively choose the United States as the model of comparator without needing to give any justification. And that's just basically following the gravitational pull of American influence in constitutional law, right? So what you're doing is looking for South-South comparisons. So, Swati Javeri, Dinesha, and I have recently co-edited a book on constitutional resilience in South Asia. That's not comparative, that's proto-comparative, but I think this is hugely welcome. You do need to answer to Siddharth, and one of the things, other than everything else that he has mentioned, is also that these jurisdictions are mutually conversant, right? Okay, not India so much with the neighbors, because India is the mini hegemon, right? Like the region does not feel it needs to learn from Pakistan and Sri Lanka and Bangladesh, but Bangladesh and Pakistan are looking at what India is doing and shaping their responses in response to Indian experience and Indian doctrine, right? And that is a very good reason to look at this region, and maybe also as a correction for India, that India could learn something from Pakistan, right? That it should not assume that because a larger, more influential jurisdiction has got it right. So I think make a virtue of where you're doing something methodologically quite unique, and we don't see this kind of work within the region. And there are many other avenues, like on trans rights, India should be learning from Pakistani legislation, for example, right? So yeah, it does open a question of why not Sri Lanka, why not Nepal, why not Maldives? Acknowledge it, caveat it, say future work, right? But okay, then yeah, so also in the literature review section, lose material that refers to American case law and German literature. And like I think Germany is a completely different context with PR based elections. The American context is completely different. Like, just there's no need for you to engage with everything that's been written in defection. Just focus on your content. If it's relevant, use it, but if not, forget it. Aradhya Sethi I've already mentioned. There are other possibilities. I'll send you an email about Gangoff's work on semi-parliamentarism, which basically says that the checking function and the confidence function cannot be performed at the same legislative chamber. That is at the heart of the problem of anti-defection, right? That it tries to make sure that the same legislative house can both supply confidence to the government and also check government, right? And Gangoff says that's impossible. That cannot happen, but it's not a practical problem because that's why we have bicameral legislatures. one confidence chamber, the lower house, which the government controls, but the upper checking chamber, which is organized in a way that the government may never control. Anyway, so there are possibilities there. At some point, you mentioned that this is a recent phenomenon. India, as you know, has had anti-defection law for 40 years. It's not recent. India has a long experience of anti-defection. So yeah, I don't know. In constitutional law timelines, 40 years does not strike to me as recent, or 38 years or whatever, right? So just maybe think about that. And the problem of, so some of Udit Bhatia's work, I think, you know, and this is a problem with some of the political theory scholarship, right? Because they set up the value of freedom of speech of the legislators so high and don't ever think about the context in which this is functional, where this may also be another normative tension, right? Party and legislator, but also freedom of expression and corruption. Frankly, what anti-defection law is really doing is stopping richer parties from buying legislators from poorer parties, right? Or at least if they function well, that is potentially one thing that they might be able to do, right? So set up those normative challenges more clearly. And if any author is not looking at the other side of the coin, not looking at this normative balancing and thinking the answer is obvious, they're clearly wrong about it, right? So point that out. Okay, I'll shut up there. If something else comes, I'll post a few links here or email it to you as well. Thanks. Great paper.
Yeah, thank you. Thank you, Tarun. So that's very interesting, because Vijay, actually, I was just having a conversation with Vijay just before we starting the workshop. So Vijay was mentioning that it's a broader project for his PhD work also. So I think both the comments from Siddharth and Tarun actually helps in the way that Siddharth actually broadly helped also to look at more into the PhD work, which may actually come into picture, and Tarun's comment may actually quite helpful for Vijay to look at the taking this work in progress to a paper for your journal article. And yeah, Swati has posted the his work on the Indian Law Review. His work is being provided here by Swati. Link is there. So yes, I'll just hand over quickly back to Vijay. So Vijay, you can actually take the opportunity to look at the comments and give your responses on that. Over to you, Vijay.
All right, good evening. So first of all, thank you very much to like all the members of the organizing committee for putting this up. And I think it would be a really helpful exercise for me, like not only for this paper, but for my broad, study on this topic. So firstly, I would like to make it clear that whatever I am doing in this paper is a very small part of my PhD topic. And in my PhD, what I am doing is I'm comparing in a very different perspective. So what I'm trying to do is I'm trying to compare defections in three models. First model is in which defections are actually dealt by constitutional provisions. Second is by simple legislations, and then next by the intra-party rules. And what kind of differences are there, distinction is there, I'm trying to explore. So firstly, I respond to some of the comments by Professor Siddharth. So I first tried to explore what all I could add regarding the political context or backgrounds in terms of Bangladesh and Pakistan. But in terms of Bangladesh, there is a very detailed paper which I have referred by Bari and Day in my paper as well, which has given the background of whatever happened in Bangladesh just before the introduction of this law for these provisions in the constitution, and then after the introduction till around 2015-16. So that's why I was not inclined to give like that kind of detailed summary again in my paper. Second thing is regarding the growth of party systems, especially if there might be some kind of presence of small parties or some interest groups at that point in time when this law was passed in the year 1985. I tried to explore this, but so like as a lawyer, it was very difficult for me to basically go into something which is I think purely an area related to political science. I also tried to actually do some consultations with people from the background of like political science, but I think now it would be helpful for me if like if I can explore that again. Other than that, regarding the choice of jurisdictions, I think I agree with these comments by Professor Khaitan that if like we see that each and every comparative study, especially whatever I have seen in India, mostly from early career scholars, is with regard to UK or US or some other Western countries. I try to explore it from the perspective that whenever these constitutions were actually framed by the constituent assemblies, political culture was nearly same, because in 47 we this partition so this partition happened, and these two countries and the Pakistan was formed as a result of partition. Then from Pakistan, Bangladesh kind of liberated in the year 1971. So I thought it would not like really be helpful for me to include this in paper. But yes, I think now I can explore more from the theoretical perspective of what other lines, especially sub-regional groups or the role of regional parties, which is I think nearly identical in India and Pakistan, or especially in the context that we have these models of state governments in India and Pakistan. Now coming to some points by Professor Khaitan, I think like it would be really helpful for me to frame it in a manner in which I can just point out what all three models are, then what are the value-based attention, especially party versus legislator, and then what is this in context of proportionality. So like I'm really thankful to both of you for these comments, and I think it's over to you, Deva.
Yeah, so yes, thanks Vijay for the responses. So I'll just now wait for any of the participants wanting to make any comment or any points regarding the work. Yeah, so is there any specific reference or any specific comment coming from any of the participants? So I think I hope all of you are able to view the links that's being shared by Tarun, as well as Swati has shared another city's article. Right. Yes. Over to you, Andres.
Thank you so much.
You're not audible, so can you just check your.
Oh dear, does it work now?
Yes, please.
Oh, perfect. Yes. Thank you. And first of all, thank you so much for. I don't know who it was who subscribed me to the mailing list and to the forum, but thank you so much. I'm so glad to be here, and thank you, Vijay, for the paper. It was very interesting to read. I research anti-defection legislation in Pakistan, and so I wanted to say some things about that might be interesting. So this idea of a Pakistani model as opposed to an Indian or Indian and Bangladeshi or Indo-Bangladeshi model, I see what you mean absolutely, and in terms of the scope of the provisions, involved and absolutely agreed, but in reading about Pakistan, I have felt a big difference in process, in the sense that Pakistan's anti-defection legislation doesn't allow for splits, even though there have been splits in Pakistan as well historically on policy issues. More recently, unfortunately, it has been the type of opportunistic stuff that these provisions are meant to guard against. But so in that sense, it's much more draconian. It is much more draconian. It has become much more draconian recently with a Supreme Court decision last year, which which held that Article 63A of the Constitution implicitly means that votes cast in violation of the anti-defection provision shall not be counted in Parliament, which means effectively that if any single party holds a majority in an assembly, that party's prime minister is the motion of no confidence as a method for getting rid of that party's prime minister or chief minister ceases to exist as a possibility, so even though the scope is much narrower than in India and Bangladesh, that is basically the end of a parliamentary system. That's no longer what we think of as a key piece of the architecture is then missing, which I think is a that reinterpretation has been a terrible idea. But even if that, even if that's one standpoint, it at least necessitates rethinking the accountability mechanisms that are to follow after that. And also a third aspect, which is not neatly processual, but the Pakistani judiciary has an attitude to floor crossing which is very dogmatic. Very one-sided, like in the sense that this is an area where there are competing interests in terms of stability of governments versus accountability through the traditional parliamentary mechanisms, the value of an individual legislator as a representative of voters versus the value of a party as representative voters is a complex area, but the judiciary since about the 90s has taken a very, very one-sided view to all of this. There is a memorable case in the 90s when Article 63A was challenged on a variation of the basic structure doctrine, and in the 5th paragraph of the case, after recounting the parties and the pleas, Chief Justice Mian, who delivered the majority opinion, says something like, it may not be out of place to note that on account of the cancerous vice of floor crossing, Pakistan has not been able to achieve political stability. That's a very, very broad and one-sided statement, also overstates floor crossing's impact in a way. So the enforcement of the provisions is impacted by that kind of judicial philosophy. So all of that just to say that I don't know, I guess as a note of caution or as a question about to what extent anti-defection provisions can be insulated merely to the scope of what legislative subjects they cover, as opposed to other dimensions which might shape their operation in practice for the purposes of your comparison.
Yeah. So yeah, thanks, Andres. I think that's quite important intervention, because I think Vijay can actually use, or I think it's also helpful for all the other listeners also. Yeah. Thanks for that perspective which you have brought in. I'll just hand over to Tarun. Tarun, yes, please.
Yeah, so I know this is fascinating, right? Because as you were describing the Pakistani model, it was all music to my ears. But you used the word draconian to describe it. I thought it sounds fantastic. It is actually, if you look at the recent piece that I've posted here from the Wire in the chat where I see 0.8 in the column, it's pretty much what I've proposed India should do. So we also need to have a chat at some point about this, because I wanted to understand why you think this is draconian. But let me put the case for. So what is clear, Vijay, is that Andras is absolutely right that you cannot simply talk about in this paper whether anti-defection applies to all votes or only confidence and supply votes. There are other dimensions which are interconnected, and the way anybody thinks about your paper or the model, etc., will very much depend on these other questions as well, right? Now, one of those questions, and Andras has put two distinct questions on the table, and here is a brief defense of the Pakistani model. Obviously, you have to make up your own mind, but obviously, and ask Andras for Andras's work as well, because part of the problem in our region is there's so little writing that who to engage with, who your interlocutors are, is so hard. So you're very lucky to have somebody in the room who's already working on this in one of the jurisdictions. And I would certainly, by the way, also in terms of process, recommend very strongly that you workshop this paper or send it for comments to some people in Pakistan, some scholars in Bangladesh as well, especially if I'm right in assuming that you're located in India. I think, I suspect that a lot of the views you will get will be closer to Andras's than mine, but, it's useful to know what the objections are and then respond to the strongest of them. So here are a couple of thoughts about why I think the Pakistani model is great, right? So anti-defection law that recognizes splits will remain ineffective in the South Asian context, because whatever the threshold of splits is, whether it is 1/3, as in India today, you can raise the threshold to half. It'll reduce the likelihood of splits. But when you have such a huge mismatch in the financial muscle of parties, when the BJP, by many accounts, is seen as the wealthiest party in the world, not just India, right? With parties like the left, like Aam Aadmi Party, etc., which have a tiny portion. So it does not matter what the threshold is. One player will always have enough money to organize the split that the law requires. And that means that the only way to get rid of the problem is to fail to recognize split. And so in my column, what I've suggested is, this goes back to what is important, the party or the legislator. So what would a model that does not recognize splits look like, right? It will look like, if you vote against a party, you lose your seat on whatever scope, right? So on the Pakistani model, if you vote against a party on confidence or supply, you lose your membership of the House, right? Now, this goes back to the original normative question, which is, in a system of democracy, what is the balance between the voice of the party and the voice of the legislator? Right? Now, that question cannot be answered, Andras, with due respect, to identifying whether this is a Westminster style model or a German style model, right? Because that is neither here nor there, right? We're trying to fix a real problem, and that's not a normative answer. That's, maybe it's not the British system, but so what? Right? If anything, this may be something that Siddharth might helpfully point out to his students to say, look, we have evolved it, we have adapted it, we have used it organically, right? So that is not the question, whether it's still a parliamentary model or a Westminster model. The real question is the normative balance between the place or importance of the party and the importance of the individual legislator is the right one in the context in which money, financial power, financial might, and not just financial might, right? Threat of prosecution, threat of all sorts of enforcement directorate, CBI, etc., right? Is used against legislators. Sometimes they're literally kidnapped, right? This is like, the Westminster model just does not make sense in a system where the ruling party just kidnaps your legislators en masse, right? 40, 50, hundreds of them, and puts them up in a resort or whatever. Right? So that context has to be acknowledged. And so if 1/3 split from the party, then they lose their seat. That will require one more thing your model will have to do, which is your model will have to have a mechanism for identifying genuine leadership of the legislative party. Right? Because if you don't recognize splits, what you're saying is the party is what the majority of the legislators want it to be. Right? So if the situation in Maharashtra, so basically you will have to involve the Election Commission to organize votes of the legislative party to choose their leader, right? Which can be ousted. Maybe 10% of the legislative party can call for a new election and oust their leader and elect a new leader, right? But whoever is the leader, it could be a collective leadership, whatever, I don't know. The models may vary, right? But if you don't recognize splits, you will have to have a model, have to have a system of recognizing who speaks for the party, who is the voice for the party. And there, my view is that that voice has to be by the legislative party, because these are the people who have won the elections, right? So now that is a balance between the voice of the individual legislator and the party. So this is not the party high command sitting outside the legislature that is dictating how the party should vote in favor of the government or against the confidence motion, right? It is the individual legislators that nonetheless collectively determine the path for the party. Some of them will lose, but that is how democracy works, right? And if they don't like what the majority has decided, they are welcome to reserve for the party to enforce its views when we know that electability in the context is nearly impossible without the support of the party for any of these individuals. So anyway, what I'm saying is I'm pushing back against this assumption of strong individuality as a normatively desirable thing. Sometimes groups and institutions can only function when the minority is willing to accept a fair judgment of the majority, right? The second thing that Andras has invited you to think about is a question of whether the vote counts or whether the vote is invalid ab initio. It does not even count, or whether you lose membership but your vote remains valid, right? Again, I think the Pakistani model is really important to stop gaming the system, where if you have already ousted a legitimately elected government by accepting bribes, even if you're ousted, the ecosystem has changed, you can be rewarded in other ways, etc., right? So the ruling party, a party with a lot of money, like the BJP, will still have reasons to game the system. It can say, look, you lose your seat, but we'll give you something else. We'll make it worth your while, right? So the system has to make sure that it's impossible for a bribed MLA to go against the party, right? So what I'm saying is that there's at least an argument that the Pakistani model, far from being draconian, strikes actually the right balance between the individual legislator and the party. But whatever your views on that, I think Andras is absolutely right. You cannot escape three supplementary questions. First is there a room for splits in the system? The second is, does the vote count as valid or no vote at all? By the way, that is not an end of the parliamentary system. This is a footnote. Not that that matters, because even if the vote is not counted, that's not the same thing as counting it in favor of the party. Right? So the party's numbers will still reduce. It will still be counted as an abstention rather than, right? So there is still some agency left for the individual legislator against their party leadership. And it's not, which strikes me to me like the right balance. And the third thing you have to answer, you have to have a response for, who speaks for the party? And I don't know what the Pakistani answer is, but I think a system will have to be clear about it. This is effectively the case about Maharashtra and Shiv Sena in the Supreme Court today. right? And who speaks to the party? Is there a role for the organizational party that's outside the legislature, or only for the legislative party? That is the key question there. Anyway, I'll shut up there. Thank you.
Yeah, thanks, Tarun. So we had Aditya raising hand. As in Aditya, you would like to go ahead?
Yeah, actually, I'm sorry. I guess we have already passed the time given for this seminar, but
Quickly, you can actually, yes, quickly you can, yeah, contribute.
I was just pondering over what Professor Siddharth was saying about his students asking the question whether, I mean, why are we still following the parliamentary form of democracy? I mean, even after it's been so long. And I was thinking like the answer lies in the original constitution. And I'm asking Siddharth's comment on this, whether it is the right way of going about it or not. I mean, in our original constitution, Article 74, Clause 1, while it was not amended, the president had a power to keep a check on not taking the government's advice. And at the same time, if we look at the few of the acts that were brought by the earlier Congress government in 50s and 51s, I believe Dr. Rajendra Prasad was under the impression that India is following a presidential form of government, where he tried to not give accent to the bills like Bihar Zamindari Bill and the Hindu Act, which Nehru had brought in. So, I mean, at that point of time, we actually had a procedure where we were trying to keep a check on parliament. But after the 42nd Amendment in the year 1976, we completely took that power away from the president. And now we only are left with the parliamentary form of democracy, parliamentary form of government completely. I mean, would it be the right way to look at it this way?
Should I answer that, Deva, or are we collecting more comments?
No, that's it. Thank you.
Pardon, I couldn't hear.
Should I answer that, or are we collecting more
in case you want to respond, we can actually just quickly take a minute.
Yeah, I know we are past our time, and but see, I mean, the reason I brought it up was because I did have clarity on Vijay's doctoral project, because I mean, of course, in his comments, he helpfully tells us that he's focusing on defection law. That's his main filter, and he's looking at different methods of defection. So that, of course, that may present a very different view of comparative analysis, because more than functionalism, then we are looking at this sort of more expressivist form, where his choice of jurisdictions may in fact go well beyond South Asia. So we'll have to wait and see his manuscript to get a better sense of that. So, so my only sort of reason I asked that question is that whether we are looking at, let's say, the concern about dysfunction in parliament, or let's say the practical questions about regime stability, the sort of baseline question which anybody would ask you is that, is this a form of government that is perhaps culturally rooted, or something which is intrinsic to a form of government that we have inherited? Now, we know that there is one section of opinion, as I said, which is much more popular these days, which is trying to say that this is largely a colonial construct which we have modified, adapted, and gone along with, and it's time to ask more foundational questions about where this comes from. Now, to be honest, that question can't really be answered, even with a serious exercise in intellectual history, because you will come across this sort of more middle ground view that, look, there is a tradition of representative government archived in some parts of our South Asian culture. But again, that may only be a fragmented answer, the kind of argument which, let's say, Professor Amartya Sen was making 20 years ago. But I think with our students, the deeper question is not about the text per se, because I think the point, Aditya, which you are making is more about the drafting history of Article 74. And it's pretty clear that Article 74 had an overhang of the previous model, which is the primary role of the governor, who was an unelected official, and how the governor could dominate or control the agenda in the colonial legislatures. So I think that is not the point being disputed, because that progression is anyway formally recorded and understood, I think, even by people who are at an initial stage of this discipline. The basic question is that if parliamentary democracy was an institutional choice, which was made by the Constituent Assembly, maybe there were pragmatic reasons for making that choice at that time, right? But what are the reasons for making that as a pragmatic choice today? So it's a far more open-ended question. And that's why I think Professor Tarun was saying that clearly we should say that it's a bit outside the ambit of the discussion on the paper. So I'm not sure if I have good answers to that, because whether we follow the colonial continuity path or whether we look at the arguments for reform, which may range from proportional representation to assured protections for minorities. Right? We don't quite get a clear answer on what exactly is the inherent strength of this model, which is something which we should accept for the future. So I think that's where those questions are coming from. And I'm not sure if a textual answer satisfied the basis of that query.
Yeah, right. So yes, I think that clarifies the point, the perspective which Siddharth was also trying to raise. So shall I call to close this particular workshop, since we have already stepped our time limit, overstepped our time limit? I feel that in case there is any further point which Vijay want to make, unless there is any specific response or other aspect, I think we can actually close our session. So Vijay, I hope in case you want to make any specific points, response. A quick point also, I think in case, yes. Yes, please go ahead.
Yeah, so I think one thing that I have realized is while I was researching for this paper is that literature on this subject in India, I think it has it has been given due consideration, especially before 2014. But after 2014, what we are seeing is so after 1985, when these provisions were actually added to the constitution, we are seeing this majority government only in the year 2014. So there were some unintended consequences in terms of already very thin this separation of power between the executive and legislature. Because if there is a political party and as mentioned by Professor Khaitan, very strong political party which is in power, which is actually controlling the executive as well as the majority of the legislator, we don't need then we don't need a parliament for any kind of lawmaking. But in context of Pakistan and Bangladesh, I think the literature available is not that much, and anti-defection law has not been given that kind of consideration, because we have to keep in mind that the executive legislature relation or the whole paradigm of these relations has actually changed after the introduction of anti-defection law in all three jurisdictions. In India, we have tried to do that, but after 2014, I don't think that it has been given due consideration, especially on the line of the majority governments. But in Bangladesh and Pakistan, I haven't seen much literature and much coverage of this subject, especially from the perspective that by using some kind of data or some kind of numbers, in case of India, that we have.
Right. Yeah. So I think with that, shall I close our session today? And it's also to just quickly point out, I think Andras has provided judgments of the Pakistan code, actually Supreme Court, on the link. So I think, yes, please have a look at it. So just to invite your attention to that factor. Yes. So thanks, Professor Siddharth and Professor Tarun, and also Andras for the excellent inputs, which actually helped our author Vijay to actually look at the broader framework of his PhD studies as well as the paper. And I'm sure that we would actually want the paper to be read on a very good journal. Hopefully, you would actually also take it for conference as well as to a journal soon, right? So with that, hope we'll wrap up our discussion today. Thanks to all the participants who actually joined, and we had a good crowd today to listen to this what I would like to call as very refreshing discussion, because frankly speaking, I'm slightly away from the specific legal world because I'm working in a business school. I'm teaching law, so I think it's always interesting for me to listen to this conversations back. Yeah. So thanks everyone. I'll just wrap it up here. So thank you. And please take note of the literature and other references on the chat also. So in case anyone wants to download, I'm just keeping it open for 1 or 2 minutes. So yes, thank you. Thanks.
Thank you, everyone. Thank you so much.